But much more usual is apparent bias. The relevant test for that is now well established, and it has been since its refinement in 2001 by the well-known case of Porter and McGill. In a recent Privy Council case from the sovereign base areas of Cyprus, Yaqub, Lord Hughes said this: "The relevant test is not in dispute. It was set out by Lord Hope, with whom the remainder of the court agreed in Porter and McGill. It is entirely consistent with the approach of the European Court of Human Rights to the requirement that a court be impartial, not only in fact, but from an objective viewpoint. Lord Hope expressed the test in these terms: the question is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased." That and similar formulations use the word biased, which in other contexts has far more pejorative connotations, to mean the absence of demonstrated independence or impartiality. Lord Hope made this clear in the case of Miller and Dixon. The appearance of independence and impartiality is just as important as the question whether these qualities exist in fact. Justice must not only be done, it must be seen to be done. The function of the right is not only to secure that the tribunal is free from any actual personal bias or prejudice, it requires this matter to be viewed objectively. The aim is to exclude any legitimate doubt as to the tribunal's independence and impartiality. So the cases emphasize that it is the appearance of justice that counts. In Pinochet, which you'll all know, Lord Nolan said, "In any case where the impartiality of a judge is in question, the appearance of the matter is just as important as the reality. It is no answer for the judge to say that he is not in fact impartial, or he is in fact impartial, and that he will abide by his judicial oath. The purpose of the disqualification is to preserve the administration of justice from any suspicion." Now, in the Caribbean context, complaints of judicial bias can be articulated in straightforward constitutional terms. What can be said is that the case concerned has not had a fair hearing by an independent and impartial court. That right is equivalent to the fair trial guarantee of Article 6 of the European Convention, and it is enshrined in the common law. Now, the consequences are these. If the complaint is upheld, then that is the end of the